All right. Welcome to the Judicial Proceedings Committee. Today is Friday, March 31st. We're going to start off on voting list number 22. And Josh, we're going to start off with House Bill 14.
House Bill 14 is the cross-file of Senate Bill 36. The bill repeals the authority of a court to grant a limited divorce and alters grounds for an absolute divorce. The difference between the two bills is that the Senate on Senate Bill 36 adopted a floor amendment to remove permanent legal incapacity as a grounds for divorce. The House bill still retains that.
I move that we conform the House bill to the Senate bill and then pass the House bill.
All right. Motion's been seconded. Is everyone okay with that? Can you explain the difference between the two?
Yeah. The difference is that the Senate adopted a floor amendment which removed as a grounds for absolute divorce permanent legal incapacity of one spouse. So we would be striking that from the House bill.
All right. Now the bill has been conformed and is before you. Motion to move the bill has been seconded. Senator McKay is in the negative. 7-1. So House Bill 14 passes. All right. Jamie actually is. All right, we'll call it House Bill 226.
House Bill 226 alters the definition of a person in a position of authority under fourth-degree sexual offense. The bill also expands the application of fourth-degree sexual offense to include certain individuals. Lastly, the bill establishes that a violation of fourth-degree sex offense may not be considered a greater inclusive crime of any other crime, and unless specifically charged by the state, may not be a lesser included offense of any other crime. It is in a different posture than the Senate version, which was Senate Bill 21. There is an amendment in your voting packet, though. The amendment is something that I had mentioned last voting session. It corrects some technical issues with the original drafting of the bill. Both the House and Senate version, I think, had that issue. But moreover, in talking with committee counsel on the other side, we agreed that the definition of person in a position of authority had some potential vagueness issues in the definition. Specifically, the defined term actually used itself to define itself. So position of authority was being used to define a person in position of authority. So the amendment in your voting packet addresses the technical issues, but it also redefines person in a position of authority to eliminate those vagueness issues. It does retain what the Senate had done in the Senate version for all of the non-school actors or school workers that are associated with a program. The age difference where they would qualify under the bill would be 6 years age difference between the perpetrator and the victim. It also includes some cleanup language related to lesser included offenses. Specifically, and if you turn to the reprint, it is at page 5 of 6. Clarifies that language. Unless specifically charged by the state, violation may not be considered a lesser included crime of any other crime, and authorizes a court to sentence either consecutive with or concurrent to a sentence for any other crime, establishing based on the act establishing the violation.
Senator James.
I just want to understand the first paragraph that just because I'm new and I don't understand how that works criminally, could you just tell me what it means when you say you may not be considered a lesser included crime? What does that mean exactly? How does that work?
So
226 HB 226.
this, I believe, was something that was at the suggestion of somebody from OAG. The issue comes out of a case where I believe 4th degree sex offense was charged along with 2nd degree assault. 4th degree sex offense carries a 1-year penalty, and 2nd degree assault carries a 10-year penalty. So the court in that case, and I'm probably oversimplifying this, but I could look at it to
No, I
give you a
just
more
want to
detailed explanation. But basically, the court said, even though the person had committed a 2nd degree assault, which would ordinarily subject them to 10 years, because more specifically, it was a 4th degree sex offense, they could only be sentenced up to the 1-year term of incarceration that was carried with the 4th degree sex offense.
And that's how the law works?
Based on that case.
So, wow, I do want to know what that, later on, just tell me what that case is so I can read it.
Okay.
So does this provision like are you trying to address that here? Is that what you're doing? Okay. Wow. Okay.
Specifically a murder issue or any issue, they all sort of it's all sort of around the same issue, but essentially it says that one is not a 4th degree sex offense is not a lesser included of any other offense, and it communicates the legislature's intent that for any other act that would establish the violation, if there was another offense that a person was also subject to a violation for, that they could be sentenced either concurrently or consecutively. So you could merge the sentence, but you wouldn't have to.
But just going forward, so I just know if I do any more criminal penalty cases or anything, I need language like paragraph 1 to avoid this case. Is that correct? Or is it just in this area?
I think that specifically, counsel and I, Judiciary Council and I sort of went back and forth about that. It was my impression that you probably just needed paragraph 2 to specify that it was the legislature's intent that you could go concurrent with or consecutive to. She had reached out to the individual from Office of the Attorney General to speak with him about that. And I think that he had wanted to proceed with with both. So paragraph 1 and paragraph 2.
So they might be redundant, but we don't know.
They seemed more comfortable with having both 1 and 2.
Okay, thank you.
Thank you. I think most of my question was answered. I think the only remaining question I have about the amendments, which I think are great, is just a little more clarity on the definition changes for person in position of authority. So it looks like we just rewrote it to be more specific, but there's no substantive change. It's just not referring back to itself. Is that the idea?
Right. The goal was that it would still capture what the committee had before. Can I say like that it wouldn't, I guess it gets a little bit muddy when we say that there was a vagueness issue before, because in and of itself, that does kind of lend itself to a substantive change. But the goal with this is that it was going to cover what the committee had intended it to cover when it was originally passed.
Right. So I'm just looking on the reprint. It's page 3 of 6 at the top of the reprint, and it spells out clearly exactly what the committee discussed, right? That's what I'm seeing. So I have no concerns with it. So unless there's more questions, we could probably move the amendments. Move the amendments.
All right, so there's been a motion to adopt the amendments and seconded. Is everyone okay? All right, now the bill's before you as amended. Further discussion. Motion for favorable has been seconded. Is everyone okay being recorded in the affirmative? All right, excellent. House Bill 222 passes unanimously. 226 with amendments, sorry. Thank you. We're now going to go on to, this is Shamari, House Bill 102. We'll take that with Senate Bill 270, but go ahead. Yeah, sorry, yeah, it's on the other list. It's on voting list 23. It's House Bill 102.
So House Bill 102 is cross-filed with Senate Bill 279. House Bill 102 establishes procedures to protect specified pets, domesticated cats and dogs when property is repossessed and failure to pay rent, breach of lease, tenant holding over, and wrongful detainer actions. The procedures are applicable to actions filed on or after November 1st, 2023. By October 1st, 2023, the Maryland Department of Agriculture must develop and publish a fact sheet on the care and protection of pets in the event of an eviction or loss of possession of property. This bill also directs sheriffs, constables, or other officials to take specific actions when regarding pets when restoring possession of premises to a landlord or a complainant. The effective date of the act is June 1st, 2023. The House bill was amended, and the amendment just makes mostly a clarifying change and simply requires that the judiciary provide a link to the fact sheets that's located on the Department of Agriculture's website.
All right, so I'd like to conform what's before the House bills before us. So that amendment's already been adopted, but I'd like to conform the Senate bill to what the House has done. So that's Senate Bill 279. All right, so since the House bill is before us, we're going to make a motion. Further discussion? Is there a motion?
Second.
Motion's been for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Okay, excellent. Bill passes unanimously. House Bill 102 passes unanimously. Now we'll bring up Senate Bill 279, and the motion is to conform the Senate bill to what the House bill did. It's been moved, it's been seconded. Is everyone okay being recorded in the affirmative? Okay, Senate Bill 279 passes unanimously. All right, now we're going to move on to, we're going to jump back to voting list number 22. And this is Jamie. The next two are yours with House Bill 758. And then we'll move to House Bill 1049.
So House Bill 758 requires the Governor's Office of Crime Prevention, Youth and Victim Services to establish and administer a reporting program for tracking the location, status, and chain of custody of sex assault evidence collection kits. It also does a few other things, but it is nearly identical to right. Let me just make sure I've got this right. So 758. 758.
Yeah, sorry. Yeah.
Whoops. .758 is nearly identical to 789. Really got to work
Yeah, you
on
gotta be careful.
some different numbers there. So the bill increases from 20 to 75 years, the time after a collection of evidence during which a sex assault evidence collection kit, other than certain specified evidence, cannot be destroyed or disposed of by law enforcement unless certain criteria are met. It is nearly identical to SB 789, which passed the Senate 45-0. The reason why they're not identical is because in the House version, the sex assault evidence collection kit policy committee is in the position to direct an entity to turn over a kit to law enforcement. In the Senate version, it's the Office of the Attorney General. This is all in uncodified language, but OAG would actually be the entity directing an entity to turn over the kit to law enforcement. The Senate bill sponsor had reached out and indicated a desire to see the House bill conform to the Senate version. So.
All right, so the motion's to conform. So what's the Senate bill number?
The House still has that.
They do, yeah. All right, so we're gonna conform House Bill 758 to the Senate bill, right?
Right.
All right, is everyone okay? Seconded? All right. All right, now the bill's before you. The motion's for favorable. It's been seconded with amendment. Everyone's okay being recorded in the affirmative. All right, bill passes unanimously with amendment. All right, now, all right, so now we'll go on to House Bill 1049.
Requires the Maryland Transit Administration to submit an annual report on assaults on public transit operators, including specified information by December 1st of each year. The report must be submitted to the local executive authority of each county, the state's attorney for each county, and specified committees of the General Assembly. The bill is not quite identical to Senate Bill 693, which passed the Senate 46-0. The House version and Senate version have a technical difference. The Senate version was a little bit more clear about when the first report was due, that being December 1st of this year. Speaking with committee counsel over in the House, it appeared that the House needed to add a requirement that the Senate had that was a requirement for municipalities to report in order to match the Senate version. So it would be to conform.
All right, so motion's to conform House Bill 1049 to the Senate version. Been seconded, everyone's okay? Excellent. All right, now the bill is before you with amended, with an amendment as, hey. Now the motion is for favorable with amendment. It's been seconded. Is everyone okay being recorded in the affirmative? All right, excellent. So House Bill 1049 as amended passes unanimously. We'll now move on to House Bill 297.
House Bill 297 alters law enforcement procedures for an officer and that an officer and a court must follow when there's reason to believe that a child who has been detained is a victim of sex trafficking or a victim of human trafficking. I won't go into the specific details of the bill, but the committee had actually passed a similar version to this. Let's see, House Bill 297. The similar version is Senate Bill 292, which passed 45-0. The Senate version requires dismissal of a specific charge when the court finds that the act was the direct result of human trafficking or sex trafficking. The House version requires dismissal of the case. In practice, the state's attorneys have said that the dismissal of the case would still allow them to rebring any charges that were also dismissed that weren't qualifying offenses or enumerated offenses under the bill that would be subject to dismissal. So, oh, sorry about that.
I can explain. Jamie, if you're welcome to.
Yeah, go ahead, Senator.
So on this tiny difference, the House took our version when it passed this, when it got to the House. In other words, they did not conform it to theirs, which shows that both chambers have now passed the same version in the SB. So for the HB, which is now in front of us, we should conform it to the Senate bill.
Want to be clear, so is the changes that it's no longer the qualifying offenses, but is it any case whatsoever?
Well, no, so. The Senate version required dismissal of the specific charge of the enumerated charges that qualified under the bill. Which is what the motion was just to change the House version to. The House version still applies to those enumerated offenses. But because the language in the House bill said that on finding that if one of those enumerated offenses was committed as a direct result of human trafficking or sex trafficking, that the entire case would be dismissed. The practical result is sort of there isn't really one. The state's attorneys have indicated that yeah, you could have a case. So, for example, you could have a case where there was a right. Right.
Versus, I was just asking if it was expanding to any case whatsoever, and it's still the same.
No,
qualifying
it's
case
still the same
charges.
posture that, right. But
The same enumerated charges. Got it. I got it. Senator James.
I'm just a little lost. When I couldn't hear you, it wasn't so, thank you so much, Vice Chairman Wallstricker, but what I was really lost on, Jamie, was just what you just said about now the bill will be that you can dismiss the charges versus the whole case on the chance, I guess, that the prosecutor is saying sometimes there might be some charges that we would want to keep or at least consider or something. So we have a little more, right? Is that it?
well,
Or it's narrower than that, okay.
it narrows the scope of what the bill is doing with respect to dismissal. So you retain the non-enumerated charges. So an example
Okay.
might be that, let's say there's a prostitution charge and a handgun charge. As part of the same case, instead of dismissing the entire case with both of those charges, you now just dismiss the prostitution charge. In practice, the difference isn't really there because they could always rebring the
Right.
handgun charge.
Okay, I understand now, thanks.
All right. So the motion is conform with the Senate. Is everyone okay with that?
Yes.
All right. Now the bill's before you as amended. The motion's for a favorable to second. Is everyone okay being recorded in the affirmative?
Yes.
Excellent. House Bill 297 passes with amendment. All right, Shamari, we're gonna go with House Bill 339.
House Bill 339 extended the time for the submission of the final report of the Maryland Lynching Truth and Reconciliation Commission to December 1st, 2025, and extends the termination date for the commission to June 30th, 2026. House and Senate versions are identical.
Is there motions for favorable to second? Is everyone okay being recorded in the affirmative? All right. House Bill 339 passes unanimously. All right, we're gonna go, let's do that one. Josh, let's do that real quick and then we'll go to facial recognition. So House Bill 232.
House Bill 232 is the cross-file to Senate Bill 653. The bill alters the definition of neglect and provisions that govern child in need of assistance provisions to specify that neglect does not include the use of cannabis by any parent or individual. Unless as a result of the use of cannabis, the child's health or welfare is harmed or placed at substantial risk of harm, or the child suffers mental injury or placed at risk of mental injury. There is a minor non-substantive difference between the two bills. So if you are on the House bill, and you go down to page 2, lines 22 and 23, The text reads, "The child has suffered mental injury or has been placed at substantial risk of mental injury." The Senate bill just reads, "The child has suffered mental injury or been placed at substantial risk of mental injury." So there's no substantive difference. It's just a stylistic difference between the two bills.
Thinking of something, and we can stick it, if we need to pass the bill, we can stick with what we have, but the fact that our marijuana legalization bill that we just passed on third reader today, I believe is an emergency bill. Because it's got to take effect July 1.
July 1 would be not an emergency bill, but it would have July 1 effective
I
date.
would, I don't want to mess anything up, but I'd alter this to from October to July because I think it should be in parity with that. But if it's gonna mess it up, I won't do it, but it really ought to be July.
That, and that because. Oh, never mind. Forget my process. I think I'm not opposed.
You see what I mean? Like there could
Yep.
actually be people
I
that
like
are
changing.
having this
I'm
issue
just
right
trying to
now,
figure out process wise.
and July 1, it can be fixed for them.
Right.
If you're gonna conform, there will be an amendment either way, so.
Right, that's what I'm saying. If we conform it to our technical language, then they have to, right? So
Okay.
if we want the stylistic choice that we passed in the Senate, then we can also change the effective date at the same time.
What's your pleasure?
We're on,
It's 232.
Yeah.
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 Chairman, I was just saying that we should technically move it to July 1 effective date, given the, it's
Yeah.
instead of October. We did not.
so that would be.
Yeah, I'm just saying, it's gonna happen. If we did that, so we go, to this bill, then we have to go back there, right?
Yeah, we're gonna have to go back.
They could receive, or they, yeah, but they would have to pop out again. If they receive it, they still have to go back to the committee to receive it, go back. Once they have, yeah.
It's not worth complicating matters, but it just, I should have thought about it earlier, but we hadn't passed the other bill yet.
Have they acted on your bill yet?
If you conform, it's a
They haven't acted.
non-substantive.
Well, if we conform anyway, they're still gonna have to go back over there anyway, so
Right.
we might as well just make both changes now then.
And
Okay.
they can change it, they can change the effective date on her bill and we can conform.
Yeah.
But they still have it.
If you could just work that with the committee council as well, Josh, to see if they're amenable to that. Okay, so then there's an amendment to change the effective date of July 1st, 2023, and to conform to the Senate. Is everyone okay with that? All right. Now the bill's before you as amended, motions for a favorable. Seconded. Is everyone okay being recorded in the affirmative? So Senator Folden is down. And everyone else is up. Okay, got it.
Senate Bill 192 establishes numerous requirements, procedures, and prohibitions to govern the use of facial recognition technology by law enforcement agents, requires training, audits, and reports related to the use of the technology, and with some exceptions prohibits the introductions of results generated by the technology in criminal or juvenile proceedings. There is an amendment in your packet. That's number 873-328/1. The amendment would increase the list of crimes for which facial recognition technology can be used. It would allow the use of facial recognition technologies which search private databases as opposed to just MVA databases and mugshot databases, provided that the law enforcement agency using the technology has an agreement in place with the entity maintaining the database, governing the methods by which images are collected into the database. And such agreement provides that the agreement would be terminated upon a material breach of those provisions. The amendment additionally removes requirements for proficiency testing, mandates additional disclosures on the use of technology, and transfers certain of the responsibilities in the bill from the Department of Public Safety and Correctional Services to the state police.
Enforcement good with it now, right? Mainly, pretty much, right?
For the most,
Right.
so. For the most part.
Okay.
I mean, there was, I think were perfectly fine with the House bill, but I had conversations with the House, my cross file, and they knew that I was gonna come in with some modifications because there was a concern with the databases.
Okay,
I was of the position that we should maintain how it was, but they continued wanting to use other databases that are created by social media.
huh,
So in order to alleviate my concern, some language was put in around that use. And because there have been some companies that have been said to have violated these companies' social media policies, scraping people's images off in and not not in compliance with the company's policy. So I wanted to make certain that if companies were engaged in that type of activity,
Right.
that the state had or that the government had an opportunity, it was a material breach.
got it. Okay, thank you.
No worries. The stalking is in it. Yeah, it is on line. We got, okay. Yeah, that was something else that in conversations with Senator Bolden, he had mentioned in his work that is something that was necessary, and I had no problem with it. So you also see from the way this bill was introduced, the crimes have been significantly increased. Again, that's a lot of give and take. So I gave a lot, and I'm hoping that they'll be hard because I need to have some of this as well. So. Move the bill. So moved.
All right, now the bill's before you as amended. Further discussion. Got it. All right, so motions for favorable, it's been seconded. All right, is everyone okay being recorded in the affirmative?
Yes.
All right, excellent. There you go. The bill passes with amendment unanimously. So now we're gonna deal with the House bill. Josh, can you go ahead and? Right, because the motion is just gonna be to conform the
Yep,
House bill, right?
It is House Bill 223.
I move to conform the House bill to the Senate bill.
Seconded. Is everyone okay with being recorded in the affirmative? Excellent. Okay, great. So House Bill 223 passes with amendment unanimously. All right, so now we've got Senate Bill 528. Josh?
Senate Bill 528 expands mandatory participation in the ignition interlock system program to include an individual who is granted probation before judgment for driving while under the influence of alcohol or under the influence of alcohol per se. Current law only requires participation of a person who is actually convicted of those offenses, and to an individual who is convicted of or granted a probation before judgment for driving while impaired by alcohol. Under current law, participation is only mandatory for someone who's convicted of committing this offense while transporting a minor younger than 16. There is an amendment in your packet, which is number 723925/1. This would allow a court in these cases which are being added to the mandatory participation to hold a hearing to determine whether participation is necessary for the safety of the community. And if the court finds that that is not the case, they would be able to waive mandatory participation in the program. By the chairman.
Yeah, I think in my meetings with the advocates for this bill or the owners of the interlocks, they talked about an affordability program. Because there's you have to do this if they make you do it. And sometimes these things are unaffordable for low income families. I wonder if that's in the bill or addressed in the bill anyway.
So the affordability program is current law, and that's something that's run through the MVA. We're very fortunate to have Chrissy Nizer as the MVA administrator, because she's actually taken this on where this was kind of hidden somewhere on their website and people didn't know that it exists. She has made an incredible effort to create a very prominent and user-friendly website so that people who need financial help, who are required to have interlocks, have access to that easily. So it's a really good question, and Christy has been a real leader on this issue.
Those funds, they come from the companies.
So it's actually not subsidized by the government. The interlock manufacturers and installers essentially agree that as participants in the state program, that they will accept a lesser amount for people who require that assistance.
Perfect, thank you.
So much, Mr. Chairman. I'm a big fan of this bill and I'm happy to see it come up for a vote. And my question is, I see that the House crossfile has not moved, as I understand it. Have we had a discussion with the Judiciary Committee? Are they in a position to be able to move this bill as well?
I think they were waiting for leadership from us to, this bill has previously not moved through this committee, and I think they're waiting for us to act. And if I could just say on the amendment, Mr. Chairman. So ideologically, I oppose the amendment. The amendment basically gives people a way out, and I support an all offender model. Nonetheless, I think the amendment is constructive and moves us substantially in the right direction. And so even though I believed in the bill as originally drafted, I think this amendment is an accommodation that is reasonable under the circumstances and gets us a lot closer to where we need to be.
All right, I'd like to move the amendment. It's been seconded. All right, is everyone okay with the amendment going forward? All right, now the bill is before you as amended. And there's discussion further. So I have a motion for favorable. It's been seconded. I'm sorry. No, we're about to do that. We're gonna do that right next one. The amendment's been adopted. Yep. Further discussion? Is everyone okay? All right, it's been seconded. Is everyone okay being recorded in the affirmative?
Yes.
Okay. Senate Bill 528 passes unanimously with an amendment. All right, now we're gonna go on to Senate Bill 505, and that is Jamie.
Senate Bill 505, as introduced, authorizes a person to file a petition for expungement under 10-110 of the criminal procedure article. If the person has been convicted of specified misdemeanors and well, there's some felonies in there too, but there's an amendment in the voting packet that allows a person to file a petition for expungement for a probation before judgment for a violation of 21-902 of the transportation article, which is probation before judgment for DUI or DWI. The petition could not be filed within 15 years after the date the petitioner was discharged from probation. So there's a 15-year waiting gap. And that's the amendment.
All right, okay. So just strips it down all the way. That's it. Now the bill is just that one offense.
I'm sorry, I thought it was.
That comes out of with the amendment. The amendment strips is just the PBJ DUI.
All right, discussion. No, you're done. It's good. Discussion.
We have, I support this idea for a PBJ, but one of the components that's necessary when we're talking about this is that their history since the offense and how have they had any other occurrences of any type of infractions with the law. And it just seems to me that if you got a PBJ for a DUI, have to wait 15 years seems pretty long. I'm just,
Because.
Look,
I'm just saying, like, we're. He's right.
Distinguish that from the other, from a PBJ from a conviction, they're allowed, they're preferred because there's a reason often where a court would grant it because they think the individual deserves it.
Right.
So my only issue is I don't know that they should be the exact same time frame. A PBJ and a conviction should not be the same waiting period. Because in no other area are they, any other area,
Right.
it's usually about 3 years for PBJ.
I agree.
What do you think? What do you think?
But here's the problem. The only way I see it is it, if it's expunged, are we showing it, if we do it at 3 years, I'm not recommending that. But is it shielded from someone being able to find out if they were to reoffend? So.
No. No.
Are we talking about? If it gets.
So I'm talking
expunged.
about if after you get a PBJ, you have been a good citizen or whatever, and if it was right now, it'd be 15 years as written, or whatever we may move it to. But if it is as currently written, you go 15 years and then you got to wait and you get it taken off, expunged. When you go back in after that and say you get another DWI after that, is it going to be considered your first offense then?
Well, can I tell you something right now?
And how many times, and but what I'm saying is how many times, like 15 years seems so long, like the shorter, like it should be consistent with other crimes that are not part one. But
So-
if you made it shorter, are we continually opening it up? Like for how many times can you get the same charge expunged?
So I've actually asked state's attorneys sort of questions along that line before, because in different areas of the law, like you do have subsequent offender penalties. Now with PBJ DUI, that's not a conviction, so it's not a subsequent offender like eligible. But let's say you know, on day one, somebody is convicted of not convicted, receives a PBJ for a DUI, and then is picked up on another one like a week later. The PBJ is still on their record, like, you know, from the last time that they were in court on it. I think that if I'm understanding the hypothetical that you just asked about is somebody receives probation, waits 15 years, gets it expunged from their record.
Yeah.
And then gets
Reoffends.
picked up again 15 years after being discharged
Mhm.
from probation the first time. Does that show up for the court?
So-
And the answer, I think, is probably not. And as a practical matter,
I don't think it does, but if 15 years, if that's what you want to keep it, then that's not a problem. You know, that's in my eyes, that it is what it is. But if you're doing it consistent with other parts of the law where it would be like a 3-year wait, if you did a 3-year wait or a 5-year wait or whatever it is for a PBJ, especially, you know, then are we, how many times? Because that's a much shorter time. So theoretically, you could be convicted or get the PBJ, wait 3 years, get it expunged. 6 months later, get a DWI, get a PBJ, wait 3 years, get it expunged. 6 months later, get another. So what I'm saying is is that correct that you could continually just keep expunging the same offense? That's why it's the 15 years. Okay.
Oh, I didn't realize I had my thing on. So I actually think 3 years is probably short for the circumstance, but under current law, a person is eligible for a second PBJ after 10 years, and I've had that happen. So my thought would be, and I'm guessing about this, but I imagine that back when the legislature decided to make a PBJ non-expungible, they decided, well, we can't do that. If they're good for 10 years and it happens again, we'll allow them a possibility of a second one in 10 years. So I think that, you know, my only thought on it is that there probably should be a bit of a waiting period, but I don't think it should be the exact same as a non-PBJ, because I think that we have to keep a distinction in the law between the two. Otherwise, what's the point? Yeah.
A couple of questions. So, one, if you were, instead of a PBJ, but you had got a conviction, just like following up on Senator Carter, what's the duration there? For the opportunity to get it expunged, or do you never get it expunged? Does that, if you were convicted versus getting a probation for judgment,
right,
in this area, what is the
it
rule?
wouldn't be expungable. So for convictions, there's an enumerated list of
Okay,
offenses,
that's
and 21902 is not on it.
And then just my 2 cents on this was, I feel like we should shorten the time period. And the reason I think, you know, is my thought was that I just know a lot of people have made this mistake once. And we've had a lot of discussions this session about how damaging probations before judgment are in employment and renting. We've even constructed a new form of probation before judgment. And I don't know if the courts could avail themselves of that new, whatever we're calling it in these cases. But to me, I feel like we should shorten it to help people who truly have made one mistake. But I would offer the idea, and I know it's your bill, Senator Muse, to allow, because what I heard the prosecutor saying is, please do not keep it from us as a public safety matter. So they would like it to be shielded and not for their purposes in case they do see repeat offending, as the Senator folded. So it would be expunged to the public, but prosecutors could see it if you start. So we shortened it to 3 or 5 years, right? but in year 7, you did this again, at least a prosecutor would be aware of it. Right, and what I wanted to ask you is, right now, while you're under a PBJ for this offense, and you reoffended, what can the prosecutor do with that information? Because I'm trying to see the value of only shielding it, right, as opposed to expunging it. So is there anything that, can the prosecutor talk about it to the judge? What can
Right.
he do to support public safety with that knowledge?
So you're looking at, I guess with a PBJ, if I understand the question correctly, like you are on a PBJ
Yes,
and you commit a new offense while on probation. So you're looking at the time that and the conviction for the first offense because you
Right.
violated the terms of probation, and then you have your new offense.
right.
So
So that's what they
Right.
use this knowledge and this.
well, and also it you know, the record is there even after you've been discharged from like probation before judgment. Let's say yesterday somebody was discharged from probation for any offense. The person commits a new offense, that's on their record, you know, for the prosecutor to see, the court to see.
Regardless of expungement?
Well, if
That's
there's
what I'm trying to figure.
expungement, so the idea of expungement is that it's no longer on their record. That can be accomplished through obliteration, which is just literally the document is no longer exists. It's also in the code that it can be accomplished through basically secure storage of the documents. In both cases, there's restrictions on how those documents can be used. When something's expunged though, and you know, I've asked state's attorneys, the reason why I've asked them is because we do have this secure storage thing, so the documents might still be around. For their purposes, at least to the ones that I've talked to, they've said there's practically no way that we would ever find out about the expunged PBJ or the expunged offense. And it's really not clear that they could even use it if they did like know that it, you know, hey, I've got this expunged offense where this document isn't supposed to exist or it's supposed to be securely stored. Can I actually even use that to tell the judge or the that
Well, can they?
this exists? I don't think that they could.
There's a difference between safe storage and shielding.
Yes.
Okay, so what I was suggesting, but this is really for the bill's sponsor, was the idea of shortening the period, because I think that's excessively long for one offense. But hearing the prosecutors saying whatever would be the right way, I think it's shielding versus safe storage, that they have some of this information. And the reason I would say it is even if they can't use it in court, it could inform them, in my opinion, that they might be dealing with somebody who's sort of a repeat offender that, you know, every 5 years and 6 months gets themselves into this trouble. And at some point, you know, it would inform, you know, what they're talking about and how they want to deal with this defendant who really is a chronic problem, but is able to sort of skirt the law with our expungement
So
process.
where I thought you were
Anyway.
going, what I thought you were going with this is that if you stayed at the 15-year mark, then you could shield from like case search at an
Okay.
earlier mark. That way it's still there, but
Okay,
but
that's another.
that's what I thought. That's what I
Well,
thought
you
you were
know,
going with
either,
it.
I didn't know you
Yeah.
could even do that. I didn't know you could do that, but if that's an option, yeah, I see that.
I didn't mean to interrupt you, but that's exactly where I was going, because I hear Senator James's concern, but I'm really uncomfortable going below the 15 for expungement. I can see that shielding would
Well-
serve the purpose of helping someone rebuild their life as necessary,
Either way,
right, without
Right.
the risk to the public. So
Yeah.
a two-tier system.
either way, good. I didn't know you could do it. And because I think that would also, Senator Kelly would agree that if we keep it at 15 years, that you've accomplished one thing, it can be expunged, which it currently cannot be. And if we add the shielding sooner than that, and I don't know when that would kick in, then we could help people avoid the employment, credit, job searching problems that a PBJ causes. And then I guess it's a question of when would you want that shielding to come into effect?
And what is consistent with most, I think 5 years, if you're gonna do that, so that person can get a job, you think 5 years or 7, what are you saying, 7? You're like 7. The shielding. And leave it 15, but at least shield it after that, and then it comes off anyway at 15, so that's a good compromise.
Yeah, I like that. But can council explain the spectrum between shielding, expungement, case search,
Right. So
alliteration?
just to sort of, I guess, like different terms are being thrown around, and there's sort of a spectrum of records disclosure and protection under state law. At the far end, you've got expungement that's more absolute, like the record is destroyed or securely stored. At the other end of the spectrum, there are statutes that prohibit certain records from being publicly referenced on the judiciary's public website, so case search. And sort of in between that, you've got shielding, which is basically rendering a court record or police record relating to a conviction of a crime inaccessible by members of the public. So that applies not just to the case search, but also to somebody going to the courthouse and requesting, that information. There's other practical effects of shielding too for employment and educational institutions. Right. So let me.
Not shielding. I was hoping it was only that was shielded from everyone except the courts. If it's out there for other people to see,
That's exactly what you get with shielding.
That's shielding.
that's it. I thought you were saying somebody else can go and request it.
Right. So actually for shielding, we're
Right.
talking, so this is further protection of the records than just saying it can't be on case search. So for shielding, which is under just 10306 of the criminal procedure article, for employment, it provides that with certain exceptions, an employer may not require a person who applies for employment to disclose shielded information about criminal charges in an application, interview, or otherwise, or discharge or refuse to hire a person solely because the person refused to disclose information about criminal charges that have been shielded. An educational institution may not require a person who applies for admission to an institution to disclose shielded information, or expel or refuse to admit the person solely because the person refused to disclose that information. So that's, in addition to it not being on case search, it's also just from public inspection. Somebody couldn't go to the courthouse and say, hey, I'd like to see this file. But it would remain accessible to law enforcement, the courts.
And then if we do it this way,
Consider that. Because it's just shielded, it's not expunged. Meaning that
Right.
difference
So
between the two.
just can we say that?
the difference between
I'm sorry, we're talking about expunging and shielding. My other question is, if we do this, it goes back 15 years. If someone is, that's when this is passed into law, and someone already has 15 years, they don't have to wait another 15 years. They can take advantage of this, almost like it's retroactive, but they will be covered by that as soon as they get to 15 years, no matter who it is. It doesn't just start from day one. Yeah, from if it's already been 15 years ago.
So,
Then they-
okay, so you're asking if the General Assembly passes this year,
Correct.
you're not saying you.
Next year, if
It's
someone wants to
clear
take
that-
advantage of it, they can take
Right,
advantage of it. If
it's-
they have the 15 years behind it.
It's not like you're waiting for 15 years from when it passes before the first people
Okay,
can
thank
actually do it.
Okay.
So to that, my read of it would be no, because expungement, doesn't work that way either.
Correct.
But I guess the best advice would be, if the General Assembly wants to make something clear, we can add uncodified language to make that clear.
Okay.
Just real quick, I get.
Right,
That's
they
what-
do. Yeah,
If someone
but
is eligible at the time it becomes law, then they can partake of it. My understanding.
So,
Result for someone of a shielding versus an expungement.
that's
Whether
a
or
question.
not, no, it's not immediately available. So does that mean it's not something required to be disclosed because it's not expunged? Under our current law, if it's expunged, it's over.
That's my question about this. So just for the record, so everyone understands. So if you shield something, then let's say you shield you make this DUI eligible for being shielded at the 7-year mark, whatever. And let's say then you get another DUI after 8 years. The court will be able to use that prior shield, that information that's shielded, in considering your second offense. Yes or no?
Yeah, they would be, and
Good. Can you put him on, please?
so
Just hold on. Like, I want to get this on the record.
just
so that- yeah.
sort of an explanation. There are exceptions to shielding, or where in current law it provides where a shielded record shall remain fully accessible. So in 10302 of the criminal procedure article, it provides in part, a shielded record shall remain fully accessible by criminal justice units for legitimate criminal justice purposes. And there's a list of about 8 other exceptions to that as well.
So just want to make sure that important feature is like very clearly explained to everyone, so that if we do move down the shielding to a smaller number than the expunged number, the court, there will still be consequences for someone who reoffends. The courts will still be able to use the prior infraction. Okay, that's all I want to make sure that everyone understands. Right. Senator Washington.
Yeah, just just to be clear, expungements, you have to apply for them, right? For this one that you do, right?
Yeah.
And you can, right, but you can be denied. Is that right? For this one, because it's not automatic. Can be denied or you cannot.
If the legislature has put in statute that after 15 years, a person is eligible, they're not going to be denied.
Well, I think there's, I could actually, I should go back and make sure I'm giving you the exact right language, but yeah, you could be denied. I think I want to call it a public safety exception if the court finds that it's not in the interest of public safety, I think is the language.
I'm looking at the website, it says even if denied, if you apply for it and you're eligible, you won't get a refund even if you're denied. So I think that you could be ultimately denied. No, not even not the refund. Yeah. No, so I think my point of asking that question is if folks can be denied expungement if they apply and if we set it at a lower level, let's say 10 years, they apply after the 10 years, but then they're approved, would the courts still have that record of them applying for that expungement? And will the courts be able to see that expungement still? Because you have to apply through the courts, right? Is that a different?
So is the question, I guess that hypothetical is, we're talking about 2 applications for expungement. A person applies at one point.
There was an issue about if somebody recidivizes or repeats the offense again, and they are expunged after that certain period of time. Let's just say, for an example, 3 years, they're expunged. They do it the 4th year. Would the courts, and they're convicted or whatever, but would the courts be able to see that person's record was expunged because they have to apply through the courts?
So my understanding is no. I could check with the legislative liaison for the courts, but my understanding is no, that once it's been ordered expunged, even the court record for the application for expungement,
everything goes away.
I'm pretty sure everything's gone, but I could check with the legislative person for the courts on that one.
Wow. All right.
Senator Weston Bolden and
I just wanted to illustrate what the chairman said a couple of minutes ago with an example. So, and using his example, so if the shielding occurs after 7 years, means public can't see it after 7 years. But if the person has another DUI after 8 years, the judge can see it. And that's important because PBJs tend to be given for first-time offenses. Judges tend to let somebody who's never offended previously not have a record, and that's why the PBJ is granted. But if you've already done it, the chances are pretty good the judge will not give you a second PBJ, but rather will sentence you to an offense. And that's why it's important the judge be able to see the first offense, even though it's shielded from the public, before it's expunged 15 years down the road.
After the 15 years, now the judge can see it.
In other words, worried about can be addressed without, while still holding someone accountable if they reoffend. That's what I'm saying. So it is a balance, and I don't know what those years look like, but just understanding that. Senator Folden.
So when you get a PBJ and a DUI, there's a conviction, is what you're saying, that it's on there. So I thought when the courts did their handling of it, if you got a PBJ and you were in compliant with all the rules and that were put in place, that it was removed, the convictions removed from your record. So the PBJ just holds it's like a placeholder that it was there. So it doesn't just drop off like okay. So on this offense. And so Jamie, what offenses and what are the timeframes with said offenses such as second degree assault or other things that nature that can be expunged? What are they? I guess what I'm saying is I know they're set with enumerated time frames.
Are we talking about for a conviction or a PBJ?
Yes.
So both.
Well, more importantly, I guess a PBJ, because that's what we're talking about.
So a PBJ, actually the provision of code that deals with PBJs.
So I apologize.
If you look at the reprint that you have at your desk on page,
which number are we?
Oh, it's if you go to page 505 and then there's count 1, 2, 2 pages after page 505. You'll see in existing law subsection C, and in C provides for in C2, the existing law provides that a petition for expungement based on probation before judgment or a stat with the requirement of drug or alcohol abuse treatment may not be filed earlier than the later of either the date that the petitioner was discharged from probation or the requirements of obtaining drug and alcohol abuse are completed, or 3 years after the probation was granted, or stat with requirement of drug or alcohol abuse treatment was entered on the docket. So basically you either have until, if it's longer than 3 years, the discharge of probation. If it's shorter than 3 years, 3 years after the probation was granted. So what this is doing is saying that for PBJs, it's an exception to the current rule on PBJs, and the PBJ petition for the DUI, DWI would be you couldn't file that before 15 years after the date that they were discharged from probation.
I guess.
Is it generally 3 years?
I guess what I'm asking
generally,
is, what I'm asking is, if I go out and there's a fight and it's a second degree assault after the conviction, how long until you can get that criminal physical assault expunged? How long do you have to wait?
So are we're talking about second degree assault?
Yeah, I'm talking about second degree assault. You actually physically go and hurt somebody.
Right. So I think that would be under the current law. I think that's the 10-year misdemeanor, there's an exception if it, there were other circumstances. Actually, so that gets tricky because there's a 15-year currently in the conviction statute. Or the expungement statute. So I'm not sure off the top of my head if it's in the 10 years or the 15 years for the current law, but I think it's in the 10-year.
Okay. Thank you.
Thank you. I lost my train of thought. This is what happens in this committee, right? So I think we're okay because I think that Senator Folden was going to go a little further than I thought he did. I just would like to reiterate my concern with this approach, that we make sure to find a balance that protects the public safety and doesn't reduce any deterrent to driving while impaired. It's very important to me that we keep protecting the public in mind as we strike this balance.
You get, you know, he's kind of get on the side. No, there's no problem. Sure.
So Senator, yeah, I was, I guess, wrong about my gut on that one. So 3203 of the criminal article, which is second degree assault, 15 years.
Provide some clarity. I'm wondering, this goes back to the whole shielding. If shielded is a person, you get an application and it asks about, I guess, criminal record or whatever. Is there an obligation for you to disclose that on your job application for purposes of a background check?
We're talking about shielding.
Mm-hmm.
For shielding? Right. There's generally not an obligation to disclose that, and you couldn't be discharged from employment for not disclosing that shielded information. I do want to say that with a giant caveat, though.
Okay.
On the same provision of law where there are exceptions for law enforcement to still access a shielded record, some of those exceptions also apply to employers that are, I think, required to have background checks. So there are exceptions for certain employers under the law there.
So would a person, let's say I'm the one who has my record shielded, if I'm applying to a specific employer, in some cases I would be obligated, although it's shielded, to disclose?
Not. My understanding wouldn't be that it would be a disclosure thing so much as that they would have access to it.
Okay, and they wouldn't be able to then discharge me for saying I didn't have anything.
Well,
That
let
was
me double check on that.
Okay, thank you.
I think that the expungement law is very clear that once something is expunged, then it's
For
gone.
expungement, it's
I
different.
understand, but that there's no similar thing in the law for shielding as expungement. What I'm saying is that the legislature was so clear on expungement that if the chairman asked earlier, like if they found it from some other source, like somebody asked about that, like a prosecutor. So let's say something was expunged, but there was a news article about it. And the prosecutor sought to use the news article to show that there had been something that's actually prohibited under our current law.
Yeah.
Because once it's expunged, it's no longer eligible to be used against anyone for anything. But shielding is different. I don't think that it has those same kinds of protections.
So in a way it does. For disclosure of a shielded record for employment is prohibited, or required disclosure is prohibited under 306, 10-306. So that's the requirement to disclose it. But the exceptions to that are under 10-302. So a prospective or current employer of or government licensing agency that is subject to a statutory or regulatory requirement or authorization to inquire into the criminal background of an applicant or employee for the purpose of carrying out that requirement or authorization, does have full access to that shielded record.
They won't be able to adversely. Then they won't be able to get you though for not disclosing.
Well, 10302B,
So you gotta
an
know the
employer,
law.
yeah, I think they could because it's an, if I'm looking at 10306, and sorry to get too technical in the weeds here.
No, I appreciate it.
But under the prohibited disclosures where it says you can't require somebody to disclose the shielded record or take an adverse action against them.
Mhm.
It says, except as provided in section 10302B of the subtitle, the employer may not require the person to disclose it or take an adverse action. 10302B is where we find that provision where the shielded record remains fully accessible. So I don't think it outright says that they can take the adverse action, but because you have that except as provided in,
They're not prohibited.
it seems like they're not prohibited from taking that adverse action.
So if you're in this position, if I'm in this position and I'm shielded, I probably need to read the law and make certain that I know which employers I need to be upfront with versus this. Thank you.
Sorry, just really quickly in response to what Senator Sanders' concern and bringing us back into the real world. So 50% or so of the workforce works for small businesses, small business employers like myself. When I hire people, I go on case search, right? And so if we shield them, they will no longer show up on case search. If the sweet spot might be 7 years, for example, then after 7 years, it would not show up on case search, and it would help a lot of people in the employment market who aren't necessarily facing background checks, but certainly employment opportunities.
What do you want to go down to for the shielding? Do you want to do this blended? Seven?
15 first one.
All right, so, hold on. Yeah, so let's just go ahead and adopt this and let's adopt, can we adopt this, the amendment first? All right, so we adopt the amendments, we walk with the bill. Is everyone okay adopting the amendment? All right, just the first one that strikes the bill and only what we started with, yeah. All right, now the bill's before you as amended. All right, so we're considering one more additional amendment, which would be to add an element of the ability to shield after 7 years?
7.
Sure, Senator James has a question.
I am so sympathetic to the concern about public safety, but I am still worried that you are 19 years old, you're 23 years old, you're starting out in life, and you made that mistake that in my childhood and youth wasn't even held against you. Not that that was right, but so then you are trying to get a toehold in the world. But for 7 years, this is going to derail you in many places, right? Or could. And so I am worried that we're just sort of splitting the baby here, but not thinking of the policy behind it. And I think Senator Musa's policy was, he wanted this is a very harsh law that we've created. It's turned out to be very, very hard on people for one mistake. And we're trying to do something with that. And 7 years to me is a very long time still to interfere with employment and housing. And they're not going to be able to do these jobs with criminal, big criminal background checks, but you could derail somebody from 19 to 26, from 23 to 30. This is when you're forming, and hopefully your trajectory forward is in that critical period, right? So I'm a little worried that we'd be really holding them back for a very prolonged time. And I'm not sure what that purpose would be if we're trying to help these people just once get a toehold in jobs and education and possibly housing. So that's just a thought.
For all those reasons, I like 5 years instead of the 7 for shielding.
I just wanted to make the point that I'm inclined to go with the will of the committee, but until and unless this passes, all of the people, Senator, that you spoke about have had no relief whatsoever in Maryland for, I don't know, whatever the legislature before my time put this into law. So anything is progress to some extent, but I agree with you, but I'm just saying like, baby steps.
After I've just kind of been poll of everyone here through hand sign language, it seems to me that they're saying 5 and 10. If you want to go beyond that, that's what everyone seems to be saying. Okay, I hear you. Yeah. I hear you. I got you, Senator Kelly. So yeah, she said.
I'm next. Oh, gosh. I would just say that going to 5 and 10 is pretty extreme. We didn't have any public hearing on this to the point the chairman just made. We haven't heard the testimony from the folks who might be drastically concerned by that. It's a radical change in the law that has been on the books for a long, long time, as far as I know. I've been on this committee for 4 weeks, but a quick Google, every attorney in town knows that you can't get expunged for a PBJ for a DWI. Like, they know it. It's been the law for a long time. I don't know why. I don't know where it came about, but I'm pretty sure that this is a pretty major change, and that, going to 5 and 10 would be too extreme for me. I'm comfortable with 15. I'm comfortable with 15 for expungement. I'm comfortable with 7 for shielding.
I was just gonna say, I think that the 5 and 10 is a reasonable application. It's not, like people are trying to start out young, they make a mistake. As long as there's no like personal injury involved in it or something like that, but I don't even want to go down that rabbit hole right now. I'm just saying 5 years to shield, 10 years. And with that PBJ for 10, you're not going to get a PBJ for that. And yeah, so with that, I say call for the vote, 5 and 10.
Both. I'm still at 5 and 10. I'll let the will of the committee prevail here, though. But from my
Want some clarity on the question that Senator Folden just alluded to, which it sounds like the chairman knows the answer to, which is, if there has been some sort of injury, are you ever getting a PBJ? Do we know that? Are we potentially giving people 10 and 5 for folks who've injured people?
There's no absolute answer for that.
Right. That concerns me. We don't have enough information. It makes me feel nervous.
You're generally not going to get a PBJ for something. You're going to get a conviction for something serious. So.
I don't necessarily agree, but I voted for it, but we just did that.
Here, let me do this. Here's my recommendation. Like, just all things considered, meaning, other chamber, getting us through, getting buy-in. I would suggest sticking at the 15, doing shielding at 7. I mean, this is giving people relief who have had no real, to Senator Carter's point.
7 and 15 down.
What about the 5 and 5 and 15?
what about the 5 and 15?
Huh? I still think it's too long. Let's think about that. 15 years. Hold on. 15 years for one DUI. That's a third of the average adult's driving life. A third. If they start at 20.
What's a terrible law?
Okay, it's a terrible law.
Who did that?
Hold on, what's going on here? Oh my Lord.
This is amazing. All right, Senator West.
We don't have a motion on the floor. I move 5 and 15. And we should.
I think there was already a motion for 5 and 10.
I made 5 and 10.
He already made the motion. I second it.
Here's the second element of this.
this sounds like something that people say to me all the time. You know, this is the first step. And if you feel strongly, you can come back next year and move the 15 down to the 10 or whatever, is my thought. But if we don't do something now, then all the people everybody here is concerned about are still in the same situation where they have nothing.
Yeah, I think if we don't move that, the 5 and 10, the other vote that we just took for the interlock for PBJs, I have to change my vote on that. Like, I just might have to. Like, I feel strongly that if we voted for that for PBJs and the courts felt like you deserved the PBJ because you didn't have anything else on your record, and we're saying that you still have to have this thing that you might not even be able to afford on your car, it's wild to me. I like 5 and 10. This is absolutely incredible. All right. So we are going to go, the motion is for eligible for expungement after 10 years, eligible for shielding after 5 years. There's a motion. The motion's, we'll run it. Roll call.
Vice Chair Waltstricker.
My head's about to explode here. But ultimately, I'm a yes, yes.
Yes.
Sidnor. Senator West.
No.
Senator Muse.
We gotta start somewhere, something, yes.
Senator Folden.
Yay.
Senator James.
Yes.
Senator Washington.
Yes.
Senator Kelly.
Nope.
Senator McKay.
Pass.
Senator Carter. Oh, yes?
Yeah.
Okay. I mean, it's not the ideal that I like, but it's better than nothing. Right. Senator McKay.
Yes.
Chairman Smith.
Well, it already passed, so that's good. Yes. All right, so now, now the bill is here. So now it's amended. We haven't passed the bill yet.
Well, I think everybody's made their mind up, but to me, if somebody has a DUI, which they shouldn't do, and they get a PBJ, I don't want them coming after 10 years, having a second DUI and the judge not knowing that they had a prior DUI and therefore giving them another PBJ. So I have to vote no.
Know for a fact that persons under our current law that have one PBJ in 10 years are eligible for a second. I have represented people that based on what they had accomplished or done in their life, whatever, the judge actually is not often, but has given them a second chance of the PBJ. And the reason for that is, yeah, they know, but they still,
Case the judge isn't gonna
even
know.
knowing, they give it to them. But I'll tell you the reason outside of like the access to the records and everything, it's the issue of the points and the fact that there's an automatic revocation of the license. And, you know, if you don't get the PBJ, so it's really tied up also with their ability to drive and function and support a family and all those things.
I just want to think about for Senator Muse's and our sake, and anybody's considered judgment. Do we have a better chance of making this bill successful by following what Senator West is worried about, what you missed? I'm worried about that, even though I so strongly support the 10 and 5, I'm beginning to think that because I had on my child pornography bill, I was also thinking about like, I didn't want to lose the option to get it somewhere. And so now I'm rethinking that. And I know that we've just amended it, but I just throw that out there that I want us to succeed. And I hope we can think about whether what we just did will help it succeed.
I think that's a very valid point, and that's what so. But here's the thing, we bump it, Senator Folden, if we could get you on 15. And Washington, we get you on 15 and 5. Right now, there's zero relief. And that way. That's a strong message if it's unanimous out of the committee. Yeah, Wes is good. He'll vote for it. Yeah. Senator Folden.
I don't like it. I just don't, look, I'm a non-drinker. And I can see the importance of something like this that is a one-time. I've seen how people get pulled over. They make a mistake and they get pulled over and they're just at the legal limit. And and to me, I'm all about the consequences, and the penalty should match the offense. And this, for driving, I know it can be a very serious thing. If you're involved in a crash, you hit somebody, it's terrible. It was a poor decision. But I have a problem when the poor decision versus something that is malice with forethought, when people go and break into homes and do all this other stuff, and that's a shorter window of time that they can have that removed than with somebody that's made some mistake and gets behind and drives. I just don't agree with that philosophically. And I don't drink. I don't care if you leave it on there forever, honestly. But I don't.
Bill, we're trying to get the bill passed and then we can fix it again. I'm backing off because I wanted us to see. Don't let perfection be the enemy of the good.
Huh? Here's my question. Who's being more of the person that's being the one that's more the eye of perfection being the enemy of the good here? When I'm sitting here saying 5 and 10 is more than appropriate. We all just 9 out of 11 of us voted for that. Now we're back to the bill in that posture. And now we're questioning that because somebody's making an argument that's a little bit louder than the other. I mean, I can get loud.
You
But
always make the argument that's
But
louder
I
than
don't
the
want
other.
to, listen,
Right.
conversely,
All right.
the people in this committee would make the same argument against if they're stuck in it. And I believe in that. And I've seen the stops. I've seen the way people do this stuff. If you're going to do that, then you might as well attach. Why don't you make it tiered and make the attachment be that if they're a 0.08 to a 0.10
All right, got it.
or a 0.1
Message received. Message received. All right. All right, got
then
it.
the message is I'm not going to vote for it.
Okay,
There you
understood.
go.
You're voting for in its current posture, just not if
Yes.
you met. All right, Senator Muse, go ahead.
And if you can live with that, it's the best we're going to get. Right now, they can't ever do it. Well, at least,
At some point, you got to stand for something.
yeah, well, I'm standing with you. We're holding what you have, and so I'm not referring to you. I'm saying to those who are still want to hold out. If we get on the floor and there's a problem, hopefully there's not, or come back next year and add 2 or 3 more years to it. But in the meantime, they got nothing. So what we just did from, was it 9 to 2? Getting 9, whatever it was, gave something, rather than us sitting around for another year waiting and not giving them any hope whatsoever. And let's come back and work on it next year if it really is that much. In 9 months, we're back here with another. So I would appeal to let's try and go unanimously with this one. In its present posture, and that's 5 and 10.
All right, so do you have a motion?
Yes, there's no motion.
Roll call. Motion for a second has been motion for favorable, it's been seconded. It's to call roll.
Vice Chair Waldstreicher.
Yes, and if I could just have a second to explain my vote. Just for the record, because I was off mic, I do prefer the longer period, 15 and 7 or 15 and 5. But I also agree with Senator Muse that I'm not going to let the perfect for me be the enemy of the good. I think this is the right thing to do. So I'm a yes.
Senator Sidnor.
I think Senator Folden makes a very good policy argument, so I'm saying yes.
Senator West.
I'm going to vote no. I think that it's important for public policy that we protect the safety of people on the roads. And the idea of having someone get a PBJ when he's 20 years old and it being expunged when he's 30, and the judge doesn't know when he has another one at the age of 30 and a half and gives him another PBJ, and that gets expunged when he's 40, and he does it a third time and endangers people on the highway. I think that's terrible. I just can't vote anything other than no. I'm sorry.
Senator Muse.
I'm gonna vote yes, and explaining my vote a little bit. You have other crimes where you have crimes of violence, you have assault, and that's that's deadly, that's intentional, and they don't have to wait that long. I just don't think that this arises to that level that we've got to be that squeamish about it when a lot are lower than this. So I think it's fair for now to go from nothing to this, and so I vote yes.
Senator Folden.
Yay.
Senator James.
Yay.
Senator Washington.
Yes, and in explaining my vote, we just voted for a bill that would require each person that has a PBJ for this instance to have an interlock in their car, a breathalyzer in their car. And so therefore, we are keeping the streets safe if both of these bills do pass. So our streets will continue to be safe as we intended to, and as the judge intended to once they gave him a PBJ. So with that, I vote yes.
Senator Kelly.
I'm really uncomfortable with this. I definitely want to, I'm gonna vote no. I definitely want to do something in this space. I think it's the right thing to do. But I'm not comfortable with how this was negotiated, and I would rather we had stayed at 15 and gone down even to 5 for shielding. I would have been comfortable with that, but as it is, I have to be a no, sorry.
Senator McKay.
Yay.
Senator Carter.
Yes, I want to explain my vote. I would have been comfortable with the longer period of time as well. But here's the issue. PBJ in every other area of our law is something that is expungible as soon as the probation is finished, or 3 years. This is the only area of the law where there's no relief at all. And so there ought to be relief for a PBJ. And so even though I think I would have even done a 2-tiered if it were me, but nevertheless, I'm voting for the bill because it has to mean something when people are granted that, when they've done everything that they're supposed to do, and they should be able to walk away. So I'm voting for it.
Chairman Smith.
Yes. All right. This is as amended, 9-2. Senator Folden, you are the floor leader. Have a good weekend, everybody.